Good afternoon to all of you. Good morning to others who may be watching from Europe. And it's such a pleasure for me to welcome all of you to the second day valedictory session of this conference, specifically on the theme, Gazing the Crystal Ball, a Step into the Future. I would like to welcome all of you to this valedictory session. I sincerely hope that all of you and your families are safe during these extraordinarily difficult times. As institutions, we have a responsibility to continue to drive change and impact, especially in these unfortunate times. And this was the reason why Jindal Global University and Kutch International decided and stood by its decision to host this conference even at this time. Therefore, with a commitment to continued evolution and reforms in the way in which our institutions will respond to very many issues, including the current theme at hand, the law and economic analysis of judicial decision-making, which has never been more important than now, at a time where additional demand as far as justice in various forms is the collateral damage of the ongoing pandemic. Jindal Global University and Kutch International had collaborated to organize this national virtual conference on economic dimensions in judicial decisions across the last 2 days. I welcome each and every one of you to this valedictory session. My very warm welcome to Dr. Montek Singh Ahluwalia, former Deputy Chairman, Planning Commission of India, and Dr. Frederic Jenny, Emeritus Professor of Economics and Co-Director, Center for Law and Economics, Essec School of Business, Paris, and Chairman, OECD Committee on Competition, for taking time off their precious schedule to be here with us and to be part of the valedictory session. Thank you for being with us. My special gratitude to Mr. Pradeep Mehta, Secretary General of Kutch International, as well as who has been with us in these 2 days and joining in partnership with Jindal Global University to host this conference. Last 2 days, we have witnessed over 45 thought leaders, including judges, legal practitioners, experts from the government and regulatory bodies, representatives from the private sector, academicians and scholars, representatives from media and civil society, including consumer protection groups, environmental advocacy groups, and trade unions, come together across 8 thematic sessions and 2 plenary sessions that included 4 keynote addresses, a book discussion, and a special judges colloquium to deliberate on some important issues related to the economic dimensions in judicial decisions, with hundreds of viewers witnessing these intellectually engaging deliberations. This pandemic has brought us under the lens various issues of justice, and using economics in judiciary will be an important next step to making the judiciary more effective and more impactful. At the same time, with economies breaking down across the globe, judicialization of the economy will be instrumental in paving a brighter post-pandemic future in our nation. Therefore, now is an important moment for us to reflect on how we can strengthen institutions such as the judiciary and the economy of our nation to strengthen our system. We draw upon experiences from different parts of the world, and I'm very happy that Dr. Jenny will be sharing those experiences as well. Today, we are in the esteemed presence of 2 leading stalwarts, Dr. Ahluwalia and Dr. Jenny, and I'm sure the next few moments will be highly enriching for us to envision this very future. Now I call upon Dr. Frederic Jenny, Emeritus Professor of Economics, Essec School of Business, Paris, to deliver his valedictory address.
Well, good afternoon, and many thanks to Jindal Global University and to Kutch and to Professor Raj Kumar and Pradeep Mehta for inviting me to address this really important conference. I want to share a few thoughts about the multifaceted interaction between law and economics, and I will focus on 4 points. This topic, of course, is a topic which has been of interest to me all my academic life as a teacher and also all my professional life, both as an economist and as a judge. So let me start by saying a few things about market economy in general, and to remind all of us that market economies are based on transactions and that transactions require legal instruments to take place. From an economic standpoint, a transaction is a situation where a supplier of a good or a service and demanders enter, presumably voluntarily, into mutually beneficial exchange. And that is, at least from the economic standpoint, an exchange which is such that none of the transacting parties is worse off, and some or all of them have a benefit. So this is what a transaction is. Second, a market economy is based on the interaction between myriads of economic transactions, which reflect the individual choices of the parties. Now, when it comes to individual choices of parties to a transaction in a market economy, we know that the behavior of the parties in the transaction, and therefore the outcome of the transaction, will be shaped by the values of the parties, the incentives that they have, and the constraints that they face. Within the constraints that they face will come, there will be various types of constraints. The scarcity of their resources, for example, the technology, which determines how the resources can be transformed into goods and services which are being transacted, the environment of the transaction, but also the legal framework in which the transaction takes place. And this brings us closer and closer to the issue of law and the issue of a judicial decision. Laws shape the incentive and impose constraints directly or indirectly on transaction between the parties to the transaction. They allow or reward certain types of behaviors which are considered to be socially desirable, and they discourage some other behavior. This can come about through, for example, the allocation of property rights, which determines who owns what and what can be exchanged, or through implementation of labor laws, which define the type of contracts that individual workers and firms can enter into, and of course those that are prohibited, or family law, which allocates assets and obligations among the family members, or environmental laws, which constrain the production of some goods and impose costs on polluters because of the negative externalities that they impose on society, or through the implementation of contract law, which sets the conditions under which obligations are exchanged between the parties to a transaction, and also provides for the resolution of dispute between the transactors, and therefore allows non-instantaneous contracts. Or through bankruptcy law, which organizes either the reorganization of the bankrupt firm or the distribution of its remaining assets among the various categories of creditors, and therefore makes credit possible. Or through competition law, which discourages and sanctions certain cooperative practices or abuses of dominance by firms with market power, or through unfair competition law, or through consumer protection law. So I've only given some examples of the constraints which are imposed by laws on transactions, which are economic in the sense that they are based on the exchange between two or more parties of services or provision of goods. So the legal framework shapes the incentive and the constraints of economic agents, whether they are consumers or business firms or even regulators. Thus, what the laws do is that they allow or facilitate or control certain transactions, with the result that the laws, in fact, determine the result of economic activity. Not only what can be produced or traded or consumed, but also what the distribution of benefit between the transacting parties is going to look like is determined by law, as well as what cost the trading parties will incur if they enter into a transaction, or how they will share the risk. All this is determined by the combination of laws. So laws are usually important for economic activity. On the other side, laws prohibit, rightly or wrongly, certain transactions and therefore prevent the emergence of some goods or services. So my first message is that there cannot be economic development or a market economy without an appropriate and effective legal background to this economic activity. By the way, we found this out very stunningly in the 1990s, when for 10 years after the fall of the Berlin Wall, and that is from 1990 to 2000, Russia, which arose from the demise of the Soviet Union, which had switched from a centralized economic model to a market economy, so its GDP fall continuously when everybody was expecting that the move to a decentralized market economy would have led to a fast development. And the reason for this unexpected result is that in the former Soviet economies, there were none of the laws which were necessary background to support a market economy. Something, by the way, which had been overlooked by a number of international donors, which thought that liberalization would necessarily lead to a development of those economies. Second, when we look across the world and when we compare the situation of various developing and developed countries, it is immediately obvious that countries which have a poor set of laws or a corrupt or dysfunctional or inefficient judicial system fare economically much worse than the other countries. If you ask yourself, why is it that Nigeria and Korea, which were at the same level of economic development in the 60s, have diverged so much, it is fairly clear that the quality of the legal system and the judicial system in Korea is much better than that in Nigeria, and that this explains to a large extent what happened to the evolution of those two countries. Let me now move from this general idea about the relationship between law and economics to a more detailed view of those two fields, and to try to bring to you the fact that both law and economics are faced or confronted analytically with some of the same issues. Let me give an example. Advances in behavioral economics and the development of artificial intelligence raise questions about the implicit model on which both the legal approach and the economic analysis rest. Yeah. This model assumes that decisions are the result.
I'm on a Zoom call. आपने मुझे कुछ भेजना था. I'll do it later, okay?
This model assumes that decisions are the result of a deliberate process of choice by individuals. This assumption explains why individuals who violate the law should be sanctioned, or why individuals should, as a general rule, be held liable for the damage that they have caused. This is also the reason why we believe that economic transactions entered into by individuals or firms are welfare increasing. But the development of behavioral economics, as well as the technological progresses in artificial intelligence, suggests that many decisions are not the result of a deliberate process of thinking, but the result of what Kahneman, for example, called fast thinking. In other words, the fact that individuals or firms rely on heuristics and have decision-making process which are fraught with all kinds of biases. As a result of this, the manipulation of the decision-making process by third parties becomes possible, as we observe, for example, in the digital world. Now, one of the consequences of this is that the decision of individuals or firms will not necessarily be consistent and will not necessarily be rational. The same individual may be led to take contrary decisions on the same issue depending on how the context of the issue is presented. A number of countries have used those results for policy purposes. I can give you two examples of this. One of them is that when it comes to organ donations, for example, the same people will not react the same way if they are told that they are assumed to be willing to give an organ upon their death unless they sign an affidavit stating that they do not want their organs to be harvested, or if they are told that they are assumed not to be willing to give an organ after the death unless they sign an affidavit explicitly stating that they allow their organs to be harvested after their death. And a lot of countries, particularly in Europe, have shifted the presumption from the presumption that people didn't want to have the organ harvested to the other presumption, the contrary presumption, with the result that there's been a massive increase in the number of transplants which have been possible thanks to the increase in the number of harvested organs. Another application of this principle is the question of whether in countries in which class actions are possible, for example, for consumers to get compensation for the harm that they have suffered from unreliable suppliers, those class actions should be of the opt-in type or of the opt-out type. Very different results from the economic point of view will be obtained depending on the formulation of the alternatives for the decision makers. Now, this has deep implications for the notion of free will and rationality, which are central both to law and economics. Indeed, the repressive laws are based on the principle that they will deter socially objectionable behaviors if parties who may be tempted to break the law are rational. Now, if it turns out that parties are not rational, then the legal system as well as the economic system tends to break down. Third, let me address very briefly the role of the judiciary and the importance of the judicial decisions. The first role of the judge, of course, is to see to it that legal prescriptions are respected, and that is to enforce the law. In doing so, the judicial decision inject into the system the kind of legal predictability which will allow economic operators to anticipate what could be the benefits or the cost of entering in a transaction with another economic operator. For example, an investor can evaluate the risks associated with an investment given the provisions and the jurisprudence in the bankruptcy law and the effectiveness of the judicial system to uphold the bankruptcy law in case of default of the borrower. The second role of the judiciary from an economic standpoint is to compensate an aggrieved party in the case of a default by one of the parties to a transaction. The law will tell the parties and the judge which damage can be compensated, and therefore what is the counterfactual that should be used to assess the damage. And the judge will have to ask the task to apply the rule to the facts of the case and therefore to assess in the particular case at hand the amount of damage. Now, this may require quite a bit of knowledge of accounting and economic understanding by the judge. The third role of the judge is to interpret the contract in the rather frequent case where the contract between the party is either incomplete because they have not anticipated all the possible circumstances which could affect them, or even because they have included provisions in their contracts which are contradictory or unclear. To illustrate this point, the result of the judicial proceeding will economically be very different depending on whether the judge takes a literal view of the contract and considers that any missing provision in the contract is not part of the contract, or whether the judge takes a wider view and tries to establish, by looking at the object of the transaction, what the parties would have agreed to if they had anticipated the circumstance that they encountered. Or, third possibility, if the judge considers how the law was meant to be interpreted in such a circumstance. There's also the case where the law itself is unclear and where the judge may have to interpret it, unleashing an anticipated economic consequences. In such a case, the judge may bear a considerable indirect economic responsibility. To make this very personal, I've lived through such a case in France when I was on the court. The case was a civil liability case. A man was born deaf, mute, blind, and paralyzed because of a diagnosis mistake made by the obstetrician of his mother. and his mother would have aborted if she had known that she was giving birth to a crippled son. So the son was seeking damages from the pediatricians for being alive. Now that case raised many complex philosophical and legal issues, as you can imagine. No one in France had ever claimed before that having been born could be a source of a prejudice that had to be compensated. So after much soul searching, the French Supreme Court decided that indeed being alive in such terrible circumstances could be a prejudice which needed to be compensated. Now, one of the consequences of these decisions was that all obstetricians were terrified at the idea that they could be held liable to compensate damages if they made diagnosis mistakes. And they all took hugely expensive insurance policies, which increased considerably the consultation fees and disrupted the market for obstetrician services, up to the point where the French Parliament intervened to prevent a repeat of such a case. Now, this is typically a case where a decision which is based on very high legal and philosophical principles has unintended economic consequences, which are seriously important. So all this suggests to me several observations. First, the economic dimension of human activity is getting an ever-increasing importance at a general level. Part of the reason is that after many centuries of very slow growth, we live in a period where technological progress allows economic development to take place when the economies are well managed, with a realistic prospect that poverty can be wiped out from the surface of the earth and that general welfare can be increased. At the same time, we live in a period where the predictable economic risks to mankind have increased. For example, climate change, which was the topic which was discussed just before this session, and the warming of the planet are a real threat to our own survival. Second, as countries develop more and more, people have the possibility to access the judicial system. Thus, the management of resources is gaining importance, and the economic dimension of judicial decisions is likely to be even more closely scrutinized in the future. Second, in a number of cases, to assess damages or to set penalty or to interpret the law, the judge will need a keen understanding of business strategy, economics, accounting, and or finance. So the question of whether judges should have an economic background himself or should be able to rely on economic experts, and if so, under which circumstances, is going to be an ever more crucially important question. I personally believe that judges cannot entirely rely on experts because they have to ask specific questions from the experts, and formulating such questions requires some understanding of the economic issues. Therefore, I believe that judges should be educated in economic matters during their formative years, just as I believe, by the way, that economists should be educated in legal principles. This is all the more so that we are in a period wherein the digitalization of the economy means that many of the classical concepts that are used either in law or economics become obsolete. For example, the experience in many jurisdictions has been that it's very difficult to apply labor laws to ecosystems when trying to deal with the likes of Uber, because the relationship between the platform and the driver doesn't fit the categories of employees or doesn't fit the contractual relationship between two independent entrepreneurs. The traditional notion of a vertical hierarchical firm does not apply to ecosystems. The idea that the provision of a service gives rise to a price is often defeated by the fact that apparently free services are routinely offered. The idea of market has to be redefined to include the possibility of multi-sided market and cross-product subsidization. So my last point is on the efficiency of the judicial system. The economic effectiveness of the judicial decision hinges not only on the ability of judges to grasp the economic background and direct or indirect consequences of the cases that they deal with, but also with their ability to deliver their judgment in a timely fashion. As we all know, justice delayed is justice denied. But in many countries, as more and more people rely on the judicial system to deliver judgment, as many cases raise more and more complex issues, and as the importance of the judicial function is not always fully grasped by governments, the judicial systems find themselves more and more unable to deliver judgment in a timely and or economically relevant fashion. I know that this is an issue in your country. It is also an issue at the European level. The risk in such situations is at three levels. First of all, that ex ante general regulations replace general laws, which are exposed with ex post analysis of each case. Second risk, that competition between national judicial systems lead to a possible loss of national sovereignty in some countries. Third risk, that reliance on alternative dispute resolution mechanism may come to be seen as a way to bypass the inefficient court system and to be more relevant than judicial decisions. In Europe, for example, in the area of competition law, the frustration with courts reviewing the decisions of competition authorities has led the EU executive and the governments in several countries to adopt tools that would in fact allow them to bypass the courts. For example, competition authorities can now impose interim measures before any substantial analysis, or they can enter into deals with the firms which avoid the pain of having to. The recent proposal concerning the Digital Market Act in Europe similarly proposes to allow the European Commission to prohibit a number of practices without having to define relevant markets or even an anti-competitive effect of those practices, and without having to look at specific cases. The second risk, I said, is that firms may decide to have their legal issues adjudicated in a different country if the judicial system of this other country is considered by them to be more effective than the judicial system of the country of origin of the firm. We have this case in Europe, where in France, intellectual property cases were dealt with by generalist judges, which were very slow and not very realistic economically. Germany created a specialized intellectual property court, which was rapidly seen as being more efficient and faster than the process in France. And a lot of transnational firms in Europe have moved their intellectual property issue to make sure that those issues would be looked at by the German courts rather than by the French legal system. Finally, there's the risk that firms, when they have a difficulty, which may have an important economic impact, decide to rely on alternatives to the judicial system, for example, on arbitration, rather than going to court. This may be in the private interest of the firm, but it's certainly not in the public interest of the development of a stable, transparent, and predictable legal system. What should I conclude of this? Well, the economic content of judicial decision is ever more important, as I said, and judicial systems are in competition with alternative modes of dispute resolution or of interventions into market mechanism. So it is crucially important that courts be given the resources to deliver swift and economically relevant judgment, and that judges be educated in economics to better assess the economic impact of their decision, and to be able, whenever they have a degree of discretion, to take into consideration the economic consequences of their judgments. Many thanks to you.
Thank you very much, Professor Jenny, for that fascinating and indeed compelling tour de force on the very complex issues surrounding law and economics and how it informs judicial decision-making process. I am also grateful to you for sharing some experiences from the French jurisdiction and how that has shaped the evolution of law and economics in your own jurisdiction. Let me now request Dr. Montek Singh Ahluwalia to deliver his keynote address. Dr. Ahluwalia, over to you.
Thank you very much. It's a great pleasure to be participating in this concluding session. You know, I especially one which has so many friends, Pradeep Mehta, and of course, Professor Jenny, I've interacted with before, and it was nice to interact again, and I hugely enjoyed the very knowledgeable and instructive address that he's just given. Actually, you rightly described it as a tour de force. And I just want to reassure you that there's no way that I can match that. In fact, when I was asked to speak, I pointed out that it's a little odd to be giving a keynote address on a valedictory session. It's more like sort of a farewell address or a goodbye note. So I assume that everybody has heard what Professor Jenny said, and I agree with all of what he said, actually. So I'm going to, give us sort of Indian perspective, not as an economist, but more as someone involved in policy. I want to clarify, I think Dr. Jenny quite rightly said that he's strongly in favor of judges learning more economics, just as he's in favor of economists learning more law. But I have to tell him that the role of economists in policy decision-making is minuscule compared to the role of judges. It's a great mistake to think that economic policy or even economic legislation is actually dominantly done by economists. It's not. And I think that's a separate issue. I mean, how carefully do we go into the structure of our laws and whether they correspond with what we think as economists would happen? I won't go into that, but I just want to make the point that you can teach the economists, and you should teach the economists more about law. I mean, simply because in a rule of law society, all economic decisions should be and are contestable, and in the end, the signal that the system gives is the signal which comes out of the courts. A good friend of mine, the former judge of the Supreme Court, said, "We're not infallible, but we are the final word." And that's a very powerful position to be in. No economist is the final word. And in fact, economists routinely get discredited every 15 years and fashions change, which is actually quite good. So let me, with those words, give you what, as an economist, I think it's relevant to think about. One is that, a long time ago, economists came to the conclusion that the performance, economic outcomes and economic performance are not the result of just economic policy. A very important determinant of whether economic policy, whatever it is, has the impact that you expect it to have is really the role of institutions. Institutions very broadly defined, but clearly the legal institution becomes a fundamental underpinning of a lot of this. So this goes back to the work of Douglas North, that the role of institutions are not just a sort of neoclassical, marginalist, market type analysis. You've got to see how will a policy operate given the kind of institutions that is going to function in. And I think there are two broad institutions that I would identify. One, at a very abstract level, is the level of social trust. I mean, that's not easy to define, but there has to be some assumption that the system is actually going to be fair. Now, by the way, whether that fair system is a rule of law system or a fair system that isn't a rule of law system, more like a rule by law system, is a separate issue. But of course, in our case, we are a rule of law system because we don't have the kind of level of trust that would justify going by a rule by law type of system. There just isn't that kind of trust. So we do need a well-functioning legal system that would command respect, that would create a sense of certainty amongst economic participants, that would enable investors to make investment decisions, saying, okay, this is what I think, these are the rules that I have to observe, and if my actions are challenged, or if I'm in some sense, somebody does something that I don't like, I can take them to court. And that somebody could be either the government. I mean, you may have a conflict between an economic agent and a government. You may have a conflict between a consumer and a producer. I think Professor Jenny's example of the obstetrician in France who was sued by somebody who he failed to diagnose would be seriously compromised before he was born is an example, and there are many, many others. And then, of course, you can be sued by other. Company A may be sued by Company B. Company A may be domestic and Company B domestic. Company A may be domestic and Company B may be foreign. But all of these need to have a sense that the laws are clear and the laws are going to be carefully and fairly and independently implemented. Now, I think there wouldn't be much debate on this. And I think it's very clear that, we fall short in many dimensions. Now, the most obvious, and I think something which we could actually resolve within a few years, is that we don't have enough courts, we don't have enough judges, we don't have enough expertise amongst the judges. And that too, by the way, as Professor Jenny said, you could react to that by simply setting up more specialized courts, which would, by definition, have judges who would then learn up the relevant economics. Or you could do what we've been doing, which is actually, in my view, not very sensible, which is to create tribunal kind of systems, where one of the judges involved happens to be a retired judge of the High Court, and the other fellows are either former civil servants or technical people or something. And I know that many of our most distinguished jurists have said that this is the wrong way of going about it, because all these decisions ultimately become subject to a final decision in the Supreme Court anyway, and it would be much better to have specialized courts rather than, as somebody called it, tribunalize the justice system. I wasn't very convinced of this earlier, but when I think about it, I am much more convinced about it. It's absolutely true, by the way, that given the volume of work and the number of people, we just don't have enough judges. And frankly, that's something which, if the government, both the central government and the state government, were willing to put a little bit of money into it, this is a problem that could be solved in 5 years, and quite frankly, it ought to be solved in 5 years. That's one point. Second, which is a little more different, is the difficulty of how do you choose judges. Now, that, of course, as you know, is currently a matter of huge controversy in India. Is the present system, the collegium-based system, the best system, or should we have a National Judicial Appointments Commission, the best system? That has run into problems, and the courts themselves have rejected the idea of a National Judicial Appointments Commission. We need to consider whether sticking with the present system is indeed the best. My personal prejudice is that it isn't, and we should be going to something like the National Judicial Appointments Institution. I think a third and very crucial thing here, which again is something which is internal to the judiciary, is the adoption of procedures that do not encourage huge amounts of delay. And my suspicion is that, again, this is something as an economist I cannot claim to have any knowledge about, but my suspicion is that if we were to subject Indian judicial procedures to what I would call state-of-the-art judicial procedure analysis, they would come to the conclusion that the thing is designed to make cases last for 20 years. I mean, there's no reason at all, in my view, even for complex cases, why both sides cannot be expected to submit extensive written submissions, but limit their argument to whatever it is, 1 hour, 2 hours, 3 hours, instead of having multi-day kind of argumentation, which takes up a huge amount of time. So I do think that these are very doable. These changes will only happen if somebody within the judiciary or the former judiciary or something develop a momentum that would give the political system a little bit of strength to promote this change. And I think we need to do that. Now let me come to another issue, and that is really more to do with the clarity in our laws. I feel that if we are going to be a rule of law society, and I think we have to be, because we are not the kind of society that could possibly be a rule by law society. It has to be a rule of law, and the judiciary has to be seen to be independent, and people should have recourse to the judiciary. Now, one of the critical things there is that the laws themselves must be much more carefully drafted than they are. And I think there are two deficiencies in this as I see it. One is simply that the government does not have access to sufficiently skilled lawyers. If you were to look at what the government pays its lawyers and what, let's say, a moderately successful lawyer earns outside, you have to assume that there's no way that they can attract good lawyers to do all the hard drafting work. I can tell you that as a former finance secretary, we spent a lot of time in trying to work out what the purpose, what the tax changes we wanted. But none of us had the technical skill to make sure that the way the thing was written up actually led to the intended effect. So there's a lot of discussion on tax policy that gets translated into a whole lot of legislation, and there's not enough high quality input to make sure that the legislation, when it goes before a judge, would be interpreted the way you meant it to be interpreted. Now, of course, we also have problems where in the famous Vodafone case, for example, we went through a very tortuous process, and the issue really was that this is what the company concerned understands the law to be. And of course, they have organized their lives in order to take tax advantages, which is what all companies do. And it would be reasonable to assume that the Supreme Court is the final arbiter of what the law was. Well, the Supreme Court actually ruled in favor of the company and against the revenue side. And we went and retrospectively, we didn't actually amend the law, we retrospectively clarified the law in order to have the same effect that an amendment. Now, this clearly, to my mind, was a mistake and shouldn't have been done. And I think you need to be very clear that when you've drafted a law, that's what you've drafted. And when the Supreme Court has interpreted it, you cannot say they got it wrong. You can say that was never our intention, and if we drafted it wrong, we better change it now. But then that change should be prospective. You cannot have a situation where an investor acts in a particular way, thinking that this is what the law actually requires him to do or allows him to do, and finds that that judgment is vindicated by the Supreme Court, and then the government takes a different view. Now, that's one example. We can find other examples of this kind. But let me give you a different type of uncertainty that gets created also. This is to some extent the consequence of the introduction of or the sanctification of public interest litigation way back in 1979. And let me say, I'm in favor of public interest litigation was meant to protect the interests of those who are voiceless and who otherwise would not actually get any hearing in the law. I'm not sufficiently knowledgeable about this, but the first actual case was about some prisoners that had been held without trial in Bihar for God knows how many years. And that's exactly what the PIL, to my mind, originally was meant to be. But then later on, it grew into all kinds of things. It grew into people who could, for example, when it came to land acquisition, you could have land acquired for a public sector project. You could challenge that acquisition on the grounds that it's unfair. Now, the truth is that the law was pathetic and the law should have been changed. But when people acted under a particular law and then you tried to stop it, you do introduce a huge amount of uncertainty. And this didn't make that much. I mean, even in the 1990s, the Narmada Bachao Andolan, Meda Patkar launched a very major campaign against the progress of that project. The project has been very successful since then. And I think she had some effect in the sense that people saw that you needed to do more, you need to do more compensation, etc. So on the whole, that thing did not lead to the obstruction of the project, although those who went to court were very unhappy that all they got was a little bit more support and not an actual stoppage. But later on, I mean, let's take, I'm saying all this really to provoke Pradeep, who's written a whole book on Supreme Court judgments. So if I get it wrong, maybe when he comes in to say his bit, he will clarify. But I was very struck, for example, in the coal case way back in 2012 or something, when a large number of coal block allocations was challenged on the grounds of all kinds of procedural improprieties. Now, it's a different thing if a coal block allocation is challenged on the basis of a specific allegation of malfeasance, which could be there. I mean, you can't, but then that should be judicially looked into. In this particular case, a large number of coal block allocations were challenged because it was felt that the procedure that the government was using to allocate these coal mines was somehow defective. I'm not questioning whether that was a correct judgment or not. As a matter of fact, the government, even that government decided that it would be much more transparent to allocate the coal mines by auctioning, because that would be transparent, and that was the right thing to do. But the point is, having been following a certain procedure and having allocated a whole bunch of coal mines to people, the court decided to cancel all these allocations irrespective of the individual merits of the case. So now this has an interesting question. You have an investor who might have said, look, I don't know what other fellows did, and maybe they did something wrong. I didn't do anything wrong. If there was something wrong with the procedure, that's not my fault. I mean, you're the government, you're doing the procedure. I accept your procedure, I apply, you give me the license, I go and invest. And suddenly you say it's canceled. It has to be accepted that, to my mind, is not the kind of signal that would encourage a lot of investment to take place. And I think connected with this is another dimension. And that dimension is that there's been a structural change in the Indian economy following deregulation. See, earlier, everything was being done by the government. Now, I wouldn't say, rightly or wrongly, there was social trust. I mean, in my view, what the government was doing in the 1970s during the control regime was economically disastrous. As a matter of fact, the best PIL would have been if Rahul Bajaj had challenged the government in 1980 under a PIL that the licensing system that was in place is damaging India, damaging the people of India, preventing the reduction in poverty, etc., etc., he would have been right. But through the 1980s, when a very control-oriented economy was being operated, and PIL had been established as a legal institution, nobody challenged. After the reforms in 1991, because the actors became not public but private, immediately the level of social trust disappeared. People were willing to trust the government making these decisions, in my view wrongly, because the government made wrong decisions, but they're not at all willing to trust the private sector. And therefore, I mean, we should have anticipated that you're not going to have the same level of trust. Therefore, you need to double and treble the level of transparency. But I think that the shift from the public sector mode to the private sector mode hugely increased the importance of credible institutions and the importance of a legal system in which people would trust in fairness. So I think the two separate issues that I'm talking about. One is we got to recognize that as we give such a big role to the private sector, which I think is the right thing to do. We have to be sure that they're operating under a regulatory and a legal system which does not allow them to manipulate the rules to their advantage, does not allow them to get any unfair advantage, subject them to competition, and then with competition, if they win, good luck to them. And I think that's actually a political transition, which I don't think has yet quite been made. I mean, today, for example, people are still not willing to see that maybe many of our public sector companies should be privatized. There's very strong opposition to that. I mean, there's a presumption that a public sector company somehow, no matter how inefficient, no matter how uncompetitive, should continue to be supported, whereas the private sector really cannot be trusted. This is 30 years after reform. This perception exists. I think it needs to be addressed head on, rather than doing it through reforms by stealth. We also, I think, need a much clearer understanding of what the consequences of particular laws should be. Let me just give you one example and then I'll stop. You know, after this horrible incident of a rape in Delhi, I think in 2012, the Nirbhaya case, there was a huge and understandable anger. And many NGOs, not all, but many were arguing that one of the things to do is to strengthen the law against rape. And they would say death penalty should be made mandatory. Now, you know, when this was discussed internally, it was pointed out that if you make the death penalty mandatory, the two things will happen. If the case has at all any uncertainty, judges will actually acquit rather than convict, because nobody would want to convict if there's even the slightest shred of doubt. Equally, if the death penalty is made mandatory, there'd be a very strong incentive on the part of the perpetrator of the crime to kill off the victim, to get rid of evidence. So now these are, you know, it wasn't easy to make these points in the heat of opinion at that time. But these were important points. As a matter of fact, we didn't make it mandatory. The death penalty was included, was left in, but in the rarest of rare cases, etc. And amongst many of the people who agitated on this, they were not happy with that. So I think we need to consider this whole issue of the design of the law. I mean, if you want judges to hew as closely as possible to the law as it is written, then the law must quite clearly indicate the intent of government and parliament, so that the judges can say that's clearly what is mean. Now, if it's badly drafted and open to multiple alternative interpretations, you're only leaving you're generating uncertainty, which no legal system can really resolve. I mean, those are some of the points that I have. Let me just say that I thank you for inviting me, and I look forward to Pradeep correcting all the many mistakes that I must have made in these few minutes. Thank you.
Thank you, Dr. Ahluwalia. It was no less than a fascinating keynote address. And in fact, you did build upon what Professor Jenny had reflected on, particularly bringing the Indian context, but also a very important aspect which many people may not fully understand and appreciate, that, I will say, you mentioned that economists are not so much involved in lawmaking in India. Even lawyers are not so much involved in lawmaking in India. Most of the time, the lawmaking process is done in closed doors, largely led by civil servants, and on fewer occasions when it ends up going to the Parliamentary Standing Committee, there are opportunities for a more public consultative process. But I think it is only fair to say that both lawyers and economists need to play a much stronger role in the lawmaking process itself. So thank you very much for that, really fantastic keynote address. Now I'm going to invite Mr. Pradeep Mehta to deliver the vote of thanks and concluding remarks of this conference.
Thank you very much, Raj. Thank you very much indeed. And it has been a fascinating 1 hour, I would say. to hear both Fred and Montek speak. It's always such a delight, the kind of wisdom that they have, and to be able to learn from them, which I continue to do. Let me start with two givens in our Indian judicial system, Fred, particularly, which is important for you to appreciate the kind of inherent drawbacks which the system has before we expect the judiciary to be able to decipher, to be able to appreciate the economic sense of any particular matter which they have to adjudicate about. It so happens that our former law minister, finance minister, one of our very brilliant lawyers, Arun Jaitley, if you remember Fred, Arun Jaitley, made a statement in the parliament one day in the 1990s. Is what reforms have led to is the failure in the quality of judges, because all good lawyers refuse to join the bench, and the practice is so enriching. And this is something which I can see myself happening, in the sense that even if you look at the present crop of our Supreme Court judges, most of them, they are not even half as good as they were about 10 years ago. And I'm sure Raj would agree with that statement. So that is one given that is very important. The second given is what liberalization has done, is to build up a system of corruption which is so endemic and is so ingrained now at every level possible. Just the other day, we heard the former Home Minister of Maharashtra asked to resign because he had told one assistant sub-inspector of police, which is probably the lowest officer in the police ranks, to give him 100 crore rupees a month. And this is being done. I mean, this is just one example which has come to light, but otherwise one can come across several such examples day to day. So now in the book that I've written is that we know that these things are given, this part of the system. So what I've tried to write in the book is that, can we think about an alternate remedy? Fine. Montek spoke about the coal mine scam, the 2G license scam, etc. Undoubtedly, there was a lot of hanky-panky in it. Now, in the coal mine scam, particularly Montek, as rightly said, there were a lot of procedural issues which were highlighted by the judiciary, that these procedures were not followed. I too remember that two honest civil servants were also caught in that war of having been punished, when I'm sure that none of them took a dime or a nickel or a paisa in that particular transaction. They couldn't have done it, and knowing them so well. And procedurally, they were certainly at fault. Now, why were they at fault procedurally, Montek? This is the important thing. If you look at the machinations which went on behind the scenes, part of the coalition politics. Coalition politics often makes people to do things which they're not to do. The telecom minister from DMK said it very bluntly. He said, I am the telecom minister of India, and I'll decide what has to be done in the telecom sector. So he dropped aside the first come first scheme, and I beg your pardon, he brought it up instead of going in for auctions, even at that point of time, in the 2G scam, and allocated spectrum and licenses to friends who could cough up money. And in the context, you were right. There were 4 foreign investors also who were caught in that. The Russians, the Norwegians, and the Emeritus, 3. And sorry, there was one more, and coming through Singapore. Now, their argument was what you rightly said, Montek. He said, look, we entered this company knowing that this is what the company is all about. And these are the licenses that they have got. So we joined them venture as equity partners, and we started to running. Now, all these licenses were cancelled. They all had to pack up. And if you remember that it was during your time when it also became a international diplomatic political issue, with especially the Russians raising noise. Norwegians kept quiet. They did not make such a noise, etc. Now, so the suggestion that I made in the book is that the court should understand that you are dealing with corruption, a system where a lot of these corruption leads to travesty of justice. Rule of fairness goes to hell. And what only matters is to how you do it. So what could be the alternate? To give an example, some excellent helicopter that we had purchased, and we discovered later that there was some corruption in it. Do we cancel the order? There was nothing wrong with the helicopter. There was something wrong with the transaction. So even at that point of time, I had argued with the opposition party, then opposition party, which is BJP. I said, why do you want them to cancel the helicopter deal? Let it come. You penalize the helicopter manufacturers for having violated the agreement that you should not have paid this kind of commission to an agent and so on. The same thing is happening, Fred, in the Rafale deal that India has now got with France. Again, allegations being made as to what is happening. Now, what does it mean? Is the Rafale aircraft bad? No, it is not bad. So the point what I'm trying to make is that the judiciary should be aware of the kind of reality. And Montek, you also hinted at the fact is that even the judiciary can be politicized, which has happened in our country. A former Chief Justice of India has now become a member of the upper house. For what reason? Another former Chief Justice of India became a governor of a state. And now we know, and this is criticized badly by the legal fraternity itself, that you don't do these kind of things, but these kinds of things are happening. So the point what I'm making is that, look, can we think of a remedy which will allow this transaction to go on and the transactees, or the transactors, to be punished adequately? It can be done, as it is happening in the coal block allocation. The CBI court is still continuing and still finding people with the fault of that. Now, in terms of the law and economics, I mean, this is something which, in many cases, what we found that Supreme Court has appointed committees to assist them on technical matters or on matters which are, which require very detailed field work and so on. And even during the PIL stages, Montek, if you remember, during the time of Bhagwati and Krishna here, commissioners were appointed by the court to go and verify whatever has come, whether the Bhagalpur blinding case. So commissioners were appointed. Now, these are all experts. They could have been experts, they could have been non-experts. But what I'm trying to say is that the system that we are suggesting is something which needs to be institutionalized. And rather than to cut off the head to cure a headache, you can't cure the headache by cutting off the head. You require a head. So that is what is the argument. Now, when you talk in terms of the investor uncertainty that we have seen, like the Vodafone case, Fred, just to tell you about the Vodafone case, it's a very classic case of how Government of India levied retrospective tax. The Supreme Court struck it down. And then, as Montek pointed out, the then finance minister brought in a law to clarify that, look, this retrospective, and that the Supreme Court order which came was also very good. I mean, coming from a well-known judge whose understanding about economics was one of the good ones of our judges, Kaparia, if you remember. So we all know that these things can happen, and that fact is that that led to uncertainty. Even the next government which came in kept on promising and hee-hawing, but did not remove that retrospective taxation provision at all. So I don't know. I mean, reasons for which I do not wish to go into. I do not wish to go into the details of the reasons here. Now, in order to improve our investors' certainty, We are engaged in the World Bank's ease of doing business rankings. We've been fighting. That is something which government has been proudly pursuing, all governments since past so on. One of the biggest problems we found is in the area of contract enforcement / dispute resolution, which is still bad for reasons what we have already spoken about. The specific relief act in India was amended to allow a court to appoint experts. So legal provision, even the civil procedure code allows experts to be formed, to be established by the courts to deal that. But it has not been happening in the manner that it could happen. That is what our plea is. Now, my contention is that the Supreme Court should highlight the key judicial principles that it seeks to uphold and not stick to only delivering judgments. There's one particular order that I have written about and spoken about is the Shiv Shakti sugar case, where the judge was wise enough to point out the judicial principle of that what you require is understand the economics of any order that you're going to pass and whether it is going to provide overall justice or not, comprehensive justice. That we all expect to have become a kind of a precedent. It has not been happening. Now, in order to come back to the point about corruption and the system with the way it is I don't think it's going to change. In one manner or the other, our politics has become so dirty that corruption is going to be a part of it, except that maybe at the very high places today it is absent. Now, what we have recommended is that the Supreme Court must set unprecedented fines and penalties on officers and politicians involved in corruption or malfeasance. And also, what we don't have under the Indian law is also to order disgorgement so that public money is returned to the exchequer. You don't have a Lincoln's law in our country, with the result that corrupt officers can get away with the money that they have made and the state has no right on it. I mean, they have done it in some cases, but those are case-to-case basis. We require a law like that. We have spoken about increasing the number of judges, etc. We have also, I don't know how it operates in France or in some other countries, but in India, we follow an old colonial system of summer holidays and winter holidays. The courts are totally shut. The courts don't follow the normal work you and I follow on a daily basis, that you could take your annual leave and what have you. So that is something which many have argued again and again, that you require, because of the fact is that the number of cases. So only the other day in this conference, one of our noted lawyers, Abhishek Manu Singh, said that since the pandemic, the total pending cases in our courts was 3 crores or 30 million. They've gone up to 40 million now. 25% increase in 1 year because of the pandemic. Courts are not able to function properly. Even virtually, a lot of cases being disposed of, but they are not able to do that. So you can imagine that situation is only getting worse. And therefore, we need to ensure that the system becomes a little more, and that the taxpayer is able to get his money from this. Another suggestion which has been there for a long time is to split the Supreme Court into 2, Constitutional Court and Appellate Court, the way you have in many countries, including in France. And the Appellate Court can have dedicated chambers for commercial and financial matters, the one in which you served, and Cour de Cassation in France, for example. And then to also follow the same thing, appoint economists and finance experts on the commercial benches and courts. Now, what India has also done in order to speed up dispute resolution is to pass the commercial benches and courts law to set up special courts to deal only with commercial disputes and benches in the high courts to deal with commercial matters. This has been very laggard. It's hardly moving properly in spite of the law. But what we've said that this needs to be expedited. And secondly, to appoint economists and finance experts which can to hear cases involving law and economics, whether they are competition laws, sectoral regulatory laws, contracts, auctions, PPP contracts, and the like. Now, our judges are fairly, I mean, humility is not their character, not in their character in that sense. That if you suggest training to judges, then they look at you, frown at it. You say, what training are you going to give us? So what we have suggested is orientation. What the National Judicial Academy does in Bhopal here is to do what are called retreats for Supreme Court judges, and which is basically where people like you and me are called to give a lecture on some aspects of the other, but they are not called training sessions at all. But in the cases of commercial courts, etc., there is a need for a mandatory basic orientation. Secondly, an important thing that you suggested by us and was also debated in the conference with a fairly good support was to set up an institution to do ex post analysis or even ex ante analysis of cases which involve economics. This could be with the Supreme Court itself or the Law Commission or the Niti Aayog. Niti Aayog is the central think tank that we have, which can monitor and evaluate cases of the Supreme Court, High Court, lower judiciary, tribunals, and even regulatory bodies, so that the understanding about it, including the knowledge about it, improves, and that a new narrative is built up that, look, these things are important for us to understand, that you can't afford to let them go by default. With that, let me thank both Montek and Fred for this, for their wonderful participation in this closing session, and it's been a very good learning exercise for me again. Raj, I would like to thank you and the Jindal Global University in particular for partnering in this particular colloquium. And there would be a record. All this is being recorded, so that this would be available for any of us to even view at a later stage. And let me also take the opportunity to thank all the participants of all the 45 thematic sessions in the conference. Thank you, Raj.
Thank you very much, Mr. Mehta. And I want to, of course, thank all the viewers as well. As I mentioned to you earlier, we've been on live in Facebook and YouTube, and we have had participants not only from India, but also beyond, and we'll share those proceedings as well. I also want to take this opportunity to thank all the staff of CUTS, as well as the IT staff in particular of OP Jindal Global University, staff from my own office, particularly Abhinav Madan, as well as Ashish Bharadwaj, the Dean of our Banking and Finance School, who worked with me and Pradeep to put together this conference. I deeply appreciate the time. Once again, I want to thank Dr. Ahluwalia and Professor Jenny for joining us in the valedictory session, which has culminated a very successful conference. Thank you very much.
Thank you. Before I forget, let me also thank my staff who have worked very hard in making this conference. Amol Kulkarni, Sakhi Shah, Kapil Gupta, and Pragya Singh.
Great. Thank you.
Thank you.
Thank you very much, Raj. Goodbye.
Thank you. Very good to see you. Take care of yourself.
Bye, Fred. Take care.
Thank you. Same to you.